As honorable members are aware, our extradition request for Atul and Rajay Gupta from the UAE was dismissed based on technicalities and inexplicable reasons. I've been in contact with my UAE counterpart and met the UAE representative in South Africa and registered our country's displeasure. We will soon announce the way forward with regards to this matter upon finalization of our engagements with our UAE counterparts. Our view remains that we have complied with all the requirements of the extradition treaty between South Africa and the UAE. And in this regard, there was no basis for dismissing our application. But we will deal with all the aspects as and when we finalize the discussions between ourselves and the UAE on the matter. Out of respect for the NPA's prosecutorial independence, the NPA will be able to explain matters related to the Section 174 Nolane matter discharge that I believe honorable members are aware of. It has been widely reported in the media. On the extradition of the two fugitives, Ms. Shepard Bushiri, Mr. Shepard Bushiri, his real name, Mr. Shipiliro Kama, and his wife, Ms. Mary Bushiri. State law enforcement officials will travel to Malawi to testify in their hearing on a set list of questions. In Malawi, the prosecuting authority of Malawi has been updating us regularly on this matter, and the central authority. They have been updating their counterparts, the NPA, and the central authority have been updating our central authority in South Africa. And where there were decisions to appeal matters in Malawi on the matter, it was joint decisions between the central authority and the authority in Malawi, and where the NPA, where the prosecuting authority of South Africa and the prosecuting authority of Malawi needed, they also agreed on a strategy and a way forward. And up to so far, we believe that the matter has reached a stage where the officials will be deployed to attend to the hearing and to testify as and when the court date is set, which we are still awaiting from the Malawian authorities. South Africa is a party to the Rome Statute of the International Criminal Court, which it ratified on the 27th of November 2000. A central feature of the Rome Statute of the ICC is that state parties to the ICC are encouraged to investigate and prosecute ICC crimes domestically. South Africa also domesticated the Rome Statutes through the adoption of the implementation of the Rome Statutes of the International Criminal Court Act 2002, which is referred to as the Implementation Act, thus affirming its commitment to an international justice system. South Africans remain committed to fighting impunity for gross violations of human rights and crimes against humanity, wherever it occurs by whatsoever means and whoever commits it. International law itself recognizes the sovereign rights of states to determine their domestic legal system and the obligations that they are willing to voluntarily carry through ratifying international treaties or exiting where no longer convenient to subscribe to them. Being party to the Rome Statutes means that South African government has an obligation to cooperate fully with the ICC by surrendering suspects against whom a warrant of arrest has been issued, providing legal assistance in investigation and obtaining evidence. Honorable members will remember that on the basis of the governing party's resolutions, the ANC, with regards to the ICC, that reads as follows: noting the ANC's previous positions on the international approach, signaling countries of the continent, withdrawal and robust engagements have positively impacted and contributed to the ICC being substantively reformed for the better. Further, noting that only a few countries in our continents have ratified the Malabo Protocol, thus delaying the establishment of the African Court of Justice and Human Rights. The ANC and the South African government must rescind the withdrawal from the ICC court and intensify its lobby for the ratification of the Lamola Protocol. Guided by the above resolutions, I proceeded to withdraw the bill that was aimed to repeal the implementation of the Act of the Rome Statutes. We agree with the Amnesty International in its annual report that the inconsistency of the ICC in the execution of its work undermines the rule of law and the work of the court itself. The fact that an investigation into the atrocities in Palestine that was opened long before the Ukraine investigation has not yet been completed, and the ICC is citing financial constraints, while member states and everyone was willing to quickly find the resources to investigate and refer on the matter of Ukraine, is clear double standards in the application of the law. And this does not help with fairness and also with the rule of law across the globe. The people of Palestine must find justice in the ICC like any other citizen of the globe. The issuing of the arrest warrant by the ICC against the Russian sitting president has brought the issue of the ICC again into the public domain. We are looking at all options in this regard, the Honorable Chairperson, including to look into the bill that may amend the implementation of the Act so as to bring it in line with international customary law, such as that is practiced in the Great Britain and in Holland, where the executive has the power to exit or suspend the implementation of the statute where it is not in the national interest to continue with its implementation.